let's get into it. This slide is actually all that you really need to know to effectively answer any multiple choice question on the multi-state bar exam for evidentiary law. Because what it is a series of steps that you take in order. And by doing them, you sort the rules. Now, as you look at that slide right now, it probably, it doesn't make a lot of sense to you. Soon, though, you'll understand that underlining the cause of action to determine whether it's civil or criminal dictates how character rule of evidence 404 and 405 are applied in that particular proceeding. And it changes remarkably between whether it's a civil or a criminal case. And you have to know that. You have to be able to identify that, because that's a node at which your decision tree branches off, and there's two different ways to potentially deal with the problem. And so asking that question, is it civil or criminal, is a fundamental thing. And that's a reading comprehension question on a multiple choice question. You've got to read for the words or the language that tells us which way it goes. So if the word like the plaintiff calls a witness, everybody in this room should know that if it says plaintiff, we're in a civil case, right? If it says prosecutor, we're in a criminal case. If it says defendant, we're probably in a criminal case. Although technically you can't have a defendant in a civil case, sometimes they're referred to as respondent. That's one of the reasons that multiple choice questions are hard, is because it's not only a law question, it's also a reading comprehension question. And you've got to know the key words that help you sort. And I'll focus on those to some degree this semester, because it gets that game out of the way and we can really hone in on the application of the law. And then I've got to situate the proceedings. And by that I mean, where are we at trial? Are we in opening statement? Are we in closing argument? Is it direct examination? Is it cross-examination? Is it redirect examination? Why does that matter? Because the form of your question, the type of evidence that you can go into, is driven by where we are in the process. So for example, I could have character evidence about the defendant that I'm not allowed to admit as the prosecutor because it's not admissible under 404A, and then the defense counsel, through a stupid question or an inartful attack, opens the door, making that information admissible. And all of a sudden, the question that I could not ask on my first cross, I now can request recross to ask because they brought up something new. If you don't understand that, if you don't see that flow, you can know the law and get the answer wrong on a multiple choice test, because you've memorized the statute and you know all the little pieces and you can vomit it up on the page, but you can't apply it in the real world. Doing the discussion problems the way we do, going through it through that lens from the very beginning, that creates the muscle to do it in the real world. And then you'll feel confident when you hit a multiple choice question in evidence. You won't even think about it. You'll just be done. So that's just one example of situating the proceeding. Could be, instead of a substance question, it could be a form question. I'm not allowed to ask closed questions that suggest the answer on direct examination. So for example, please turn and introduce yourself to the class. What's your name?
Morton Schaefer.
Can everybody hear? Ask the witness, please speak up a little bit, sir. Okay.
Morton Schaefer.
Mr. Schaefer, where are you from?
New Jersey.
New Jersey. What part of New Jersey?
Central.
How long did you live in New Jersey?
20 years.
Was that your early life? Is that where you grew up?
Correct.
What's the thing about growing up in New Jersey that you remember most fondly?
The beach.
The beach?
Jersey Shore.
The Jersey Shore. And this is before Suki and the TV show, right?
Long before
Long
that.
before. What's the thing about New Jersey that you miss the least?
The traffic.
Why is that?
There's cars all over the place. Everybody goes their own way. They don't always use turn signals. Frustrating to figure out what people are trying to do.
So, that is a direct examination with open-ended who, what, when, where, why, how questions, controlled by Federal Rule of Evidence 611. If I got a procedural question where a part of a direct was there, I'm looking to see the form of the question. Does it comply with the rule? Now, bar examiners love those kind of questions because it tests both substance and procedure at the same time. The substance of the rule and the procedure of how cases are actually conducted. And that's a thing that the National Conference of Bar Examiners finds interesting. And because they find it interesting, people who write multiple choice questions for bar exams find it interesting. So it's just a thing you need to know, even if you are never, ever, ever going to be a trial lawyer, so that you can pass the bar. Now, I could do cross-examination. Mr. Peoples,
Yes.
you're from Memphis.
No.
You worked in Memphis.
Yes.
Memphis, Tennessee.
Yes.
You had a job there.
Yes.
You happen to be an African-American male.
Yes.
You dealt with African-Americans in your job.
Yes.
You weren't a counselor.
This is correct.
Is that yes?
Yes.
You weren't a doctor.
Yes.
You weren't a social worker.
Yes.
You were a police officer.
Yes.
A police officer policing other African Americans.
Yes.
See, all yes, no questions. Thanks, Ty. I appreciate that.
No problem.
All yes or no questions. I am making an argument when I'm asking cross-examination. I'm not allowed to do that unless we're on cross. And the reason that I'm not allowed to do that unless we're on cross is because I can imply through the structure of my questions almost anything that I want, and I'm only bound by the rules of evidence and what the judge is going to let in, whether or not it's relevant to the proceedings. Now, if that had been a case where, God forbid, he was on trial or he was a witness to abuse of an African American by another police officer, that might be relevant, even though it's uncomfortable to talk about race sometimes for some of us, because we don't want to look at it clearly or we bring our own preconceptions to it. It's actually what the trial lawyer has to do to effectively assist. And it's one of the reasons that in this class we have to have clear eyes about difficult issues. Unwed mothers, drug use, racial differences, intellectual differences. Because it's in those differences that the persuasion and the understanding of why people did what they did occurs. And so there's a courage part with being a trial lawyer that is not present in some of the other ways that people practice law. Because you have to deal with those uncomfortable moments. So cross-examination, I can imply anything. I can turn you sideways and make you look like you've done something that you haven't even. And if I'm really good, I might nod my head up and down while I'm asking you the question. And when someone nods their head up and down at you, it is almost impossible. You have to physically stop yourself from saying yes. Not that I would ever manipulate someone that way. So being on direct or redirect or cross-examination is a fundamental question that we have to ask ourselves, because it helps us sort the law. And the next thing I need to know, is it a party or is it just a witness? A party, defendant, plaintiff, respondent, accused, a party is treated differently by both the character rules and the evidence rules for hearsay. So for example, let's say, God forbid, we were prosecuting Mort for something. Because Mort was the defendant, anything that he's ever said in any format, if I can verify it, is admissible as an admission by a party opponent under Federal Rule of Evidence 801. which by law excludes certain things from hearsay consideration. So if he's posted something on a blog, if he's written a paper about how X, Y, or Z should happen, I can offer it for the truth of what he said, just by virtue of his status as the defendant in the case. In a civil case, if I'm the opposing party, if I'm the defense, I can do that to any statement that the plaintiff made. And if I'm the plaintiff, I can do that to any statement that the defendant made. So all those things that Rebecca Hartwell says in her written statement, or that she puts in the newspaper, if I'm the plaintiff, I can admit any of it. I know it's going to come in. It's going to come in as an exclusion to the hearsay rule. And if I'm Rebecca Hartwell's lawyer, anything that Mrs. Washington said is going to come in as an admission by a party opponent, because they're a party. And the hearsay rule changes if you're a party. If they're not a party, if they're just a witness, now I have to dig deeper in the hearsay rules to find a theory of admissibility for their prior statements. I also have to look at the rules for what I'm allowed to question witnesses about. For example, if you're a convicted felon in the federal court system and you take the stand to testify, I can cross-examine you on your previous conviction, as long as I meet the requirements of Federal Rule of Evidence 609. And in the federal court system, I can not only cross-examine you on the fact that you're a convicted felon, but what you were convicted of. Why? Because we have made a policy decision that convicted felons understand how the system works and they are less truthful. And there's rules and limitations that we'll learn this semester when we learn impeachment. But I've got to know if it's a party or a witness. Because if it's the defendant, there's a reverse balancing test. And it's more difficult to admit the conviction. Why? Because of the overwhelming prejudice that the jury will have if they know the defendant's been convicted of a crime. Especially if that crime happens to be similar to the crime which they're currently charged at trial. If it's just a witness and not a party, then I don't have that same concern. Well, because that's a place where the law flips or flops either way, just like character evidence is a place where the law flips or flops either way, that's a place where we have to be able to deal with it at trial, because it can be confusing, and it's also a place where the National Conference of Bar Examiners like to write questions. Because if they write the right question, they could get credit for asking you about 3 different evidentiary rules in one question. Those are also the questions that separate the wheat from the chaff, the people who truly understand the law as opposed to the folks who don't. This rubric that I'm talking about right now will help us cut through the confusion. So what I would suggest is that you use it every time you do a practice multiple choice question, and you train yourself to follow these steps. Later on, when we get to hearsay, I'll give you another series of questions for hearsay. But until we get to hearsay, this is all you need to begin sorting multiple choice questions. It's a tool, it's a trick, it's a logical approach that helps you separate which way to turn. It helps you get through the maze of the evidentiary question. It's incredibly useful. And then the last thing you look for is the purpose for admitting the evidence. Is it substantive or is it to impeach? Because if it's substantive, I have to establish relevancy, I have to lay foundation, and if it's an out-of-court statement, I have to have a hearsay exception or exclusion. If it's not an out-of-court statement, I establish relevancy, I lay foundation, and then it's admitted to prove whatever it is you're offering it for. That's kind of a fascinating thing. So knowing whether I'm asking the question substantively or to impeach is really important to me. If it's to impeach, I don't care whether the statement is true. I just care that they said it sometime before trial and they've said something different on the witness stand. So this rubric will really be helpful, guys. It will give you what you need to get through it. Now, when I think of the background, the ground rules for studying evidentiary law, we have to start with what job does each person who's in the room have, right? What job do they have? Federal Rule of Evidence 103 establishes the rights and responsibilities of counsel at trial. And this rule is really interesting because what it does is it places on the lawyer the burden of raising objections to evidence that is admitted. And it's got a catch-all that says that if you don't raise the burden appropriately, you've waived the issue on appeal. It puts it on the shoulders of the advocate, not the judge. So you've got to understand that rule. You've got to see how it works, and then you've got to be able to fashion the language in court. Your Honor, but for your ruling on this motion, I'd like to make an offer of proof since you've excluded. But for your ruling, Your Honor, I would have called the witness and they would have testified substantively as follows. Boom, 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 boom. It is our belief that that evidence is relevant for the following reasons. XXXXX. Why am I making an offer of proof? Because I'm making the record for the appellate court. And if it's an issue that's sufficiently important, one of two things is going to happen. The judge is going to change their mind and I'm going to get to do it because I put them on notice in the record. I've told the appellate court that this is a problem. Or I'll have a bite at the apple on appeal that I would not have if I did not raise the issue. If I did not raise the issue. So we're going to look at 103 a lot about that. 104 and 105 is designed to tell the judge what they're supposed to do. And 104 has this concept of conditional relevancy. It tells us that the judge is the gatekeeper to determine whether or not evidence is admissible. It fashions a balancing test for us that shows what the judge can and cannot do. And then 105 plays with this concept of limiting instruction, where a piece of evidence can be admitted for one reason, but is not allowed to be used for another. And there's a wonderful philosophical discussion to be had about whether or not that actually works. Are people capable of following a limiting instruction, or is it once it's heard, it's heard? We'll talk about that. And then we've got logical relevance and legal relevance. Logical relevance is having any tendency to make a fact more or less believable. And legal relevance is a balancing test between substantial dangers of unfair prejudice, confusion, waste of time, and its probative value. And that balancing test, that game, that 403 game, is actually the pivot around which the entire federal rules of evidence turn. That's the pivot. That's the game. Unless the rule specifically applies a different relevancy balancing test, and there are only a handful of rules that do that. So understanding 403, really getting it, and diving deep on it and being able to apply it, that's a core competency for a lawyer. It's a core competency. And it's an extremely important job for anyone who's going to be a prosecutor or a defense attorney or a plaintiff's lawyer. If you don't understand relevancy, you're in the wrong business. And it's a logic game. I call 403 legal relevancy because it's a legal test that will exclude factually worthwhile evidence for a policy reason. Evidence that we might normally rely upon in the course of our lives to make a decision, they don't let in because they're worried about the jury using it the wrong way. So playing with 403 is important to us. And then the standard of review, and I've already told you that's abuse of discretion unless it's a constitutional issue. We'll talk about that briefly next week, but I'm not too excited about it because it's at most maybe one multiple choice question, and it's like the cost of admittance. Well, of course there's a standard of review, and of course I know it. It's just not that big a deal. So that's the background of the core concepts that I think that you need to be looking at as we begin to really dive into evidentiary law. And that actually takes us through basically the first 3 blocks of instruction on our detailed syllabus. We're going to look at these through the rubric of a few cases and a lot of discussion problems and the 2 case files. That's how we're going to play with these rules as we begin to understand them. Now, those rules cut directly to preliminary questions of admissibility. Lawyers want evidence to be considered by the jury. In order for the jury to consider the evidence, it has to have been deemed to be admissible. And the way it works, if I'm the lawyer who wants to admit the piece of evidence, I have the burden of establishing preliminary facts that make the court feel comfortable in letting the jury see the evidence. And those preliminary facts are established through direct examination, the laying of foundations, the establishing of relevancy. And it's my job to do that. Once I've done that, I then offer the exhibit or the testimony into evidence. If it's testimony, once it's said, it's been admitted into evidence. If it's an exhibit, I have to go through a formulaic process called laying the foundation. And that's grounded in Federal Rule of Evidence 900, 901, 902, 903, 904. And those we'll learn in detail this semester. They're not hard. It's basically, is the object what it purports to be, and is it in the same or substantially the same condition, or is it a demonstrative piece of evidence? And if it's fungible, i.e. we can't tell what it is by the way it looks, then we also have to establish chain of custody to make certain that it has been modified in some fashion. Once we as the party seeking admission have done that, the judge then rules on the admissibility of the item. Once it's admitted, the judge's job as to that piece of evidence is done. The evidence is in, it's been accepted by the court, and then the jury has the sole job of determining the weight and credibility of the evidence. And because that's the jury's sole function, the judge can't invade that purview. So the jury can hear evidence that seems to clearly establish guilt, but might decide because of the source of that evidence that they're not going to give it any weight. They're not giving it any weight. Classic example of that is the O.J. Simpson trial, which none of you remember, but all of you have watched in some sort of made-for-TV docudrama. When Mark Furman was identified as a racist, having used the language that he had used, that trial was over with, particularly with that jury. The trial was done because they didn't trust the cops. They were looking for a reason not to trust them, and my God, Furman gave it to them on steroids. There was weight that Simpson had committed the crime. There was blood that was found at his home. There was blood that was found in his Bronco. He had injuries to his hands. It didn't matter. Because the only person who was involved in the collection of that evidence was Furman, who had done some things that were so beyond the pale that you could not rely upon him to be credible. So the jury, under their authority, under the Federal Rules of Evidence, discounted anything that Mark Furman said. And because of that, O.J. Simpson was acquitted. Maybe he did it, maybe he didn't. I have my own opinion. But it doesn't matter. Legally, he's not criminally responsible, although he was later found to be civilly responsible. Why? Because a criminal defendant has the right against self-incrimination, and you can't force them to testify. Sometimes they have the right, but they don't have the ability. They just run their mouths. You might think of someone in the world right now who's like that. Good buddy of mine, his name's Dean Sirakas. He practices law down in St. Pete, Florida, Clearwater. Dean is a Columbia grad, prosecutor for most of his life, and then a criminal defense lawyer. In his office, he has a giant marlin, which you might think of as a sailfish, you know, that big, long, beautiful blue fish with a fin. And there's a sign that hangs underneath it. It says, if I kept my mouth shut, I wouldn't be hanging on this wall. You know, defendants snatch defeat from the jaws of victory by talking, because it is not in their best interest. I cannot think of an instance in my career where a defendant talking helped the defendant, unless they were completely innocent and I was able to verify that what they said was true. I can't think of a single time. That's why, when you're in the criminal enterprise work, the first thing that your counsel who's on retainer tells you is shut up and ask to speak to me. Because they're asserting your constitutional right. Because you've got that right. And you've got to use it. But having a right and having the ability to use the right are sometimes two separate things. So that's the way that preliminary questions of admissibility are dealt with. And after we're done on Tuesday, you'll understand that 103, 104, and 105, with a little bit of 403 thrown in, those are the rules that the court is using to determine the admissibility of evidence. It's just kind of fascinating the way it all goes together. When I look at 104, 104 tells me that the judge is the determining factor for the qualifications of a witness, for a lay witness, whether they have personal knowledge about the things that they want to say, the existence of a privilege, whether or not a privilege applies, such that evidence should be excluded, and whether a hearsay exception applies. The judge makes that determination. And in the federal court, you know what's amazing? Is that I, as the judge, can consider inadmissible evidence in determining whether or not other evidence is admissible. In some state jurisdictions, you can't do that. You're only allowed to stay within the four corners of what has previously been admitted. And I will remind you guys, these slides will be placed on the Google Classroom. In fact, I think they may already be there, right? So, if you don't get it all written down because I'm talking too fast, don't worry about it. This is the judge's power under 104A. Judge gets to do that, nobody else. Under 104B, they get to decide about conditional questions of relevancy and fact. We'll talk about that too. Judicial notice, 201. There are two types of judicial notice, permissive and mandatory. This is the only time I will speak about judicial notice the entire semester from a lecture perspective. If you are unfortunate enough to get a judicial notice multiple choice question on my exam or on the bar exam, you need to remember the two categories of permissive and mandatory, what the requirements for the judge to take notice are, and how it works. This flow chart literally is all you need to know to effectively and cogently answer a judicial notice question. I've made it available to you. It's attached to the PDF that's in our Google Classroom. When you do some multiple choice questions about judicial notice, if you have it by your side, it might help you truly comprehend it. If you guys later on have questions for me about it, I'm happy to talk about it. There's case law on it in certain circumstances. Kind of revolves around whether the parties agree or disagree as to whether or not a notice should be taken. There's actually some things in the Hartwell file that if you were a lawyer, you might want the judge to take judicial notice of. Because what the judicial notice does is it establishes that fact conclusively for the jury. That's a useful thing, right? That's a useful thing. Burden of proof. Y'all spent the entire first year of law school, and some of you the first and second year of law school. Did anyone ever tell you what the burden of proof is in a case or for a particular type of issue? You probably all heard beyond a reasonable doubt, right? And you think that applies to criminal cases. Well, riddle me this, Batman. What does beyond a reasonable doubt mean? What does it mean? Is it a number? Is it a ratio? Or is it just it's like, I know it when I see it. What does beyond a reasonable doubt mean? How do I define it? How do I use this standard to show a jury that I've proven my case to that level? Well, if you go and read the case law, or as a shortcut, you go and read the instructions in the jurisdiction where you're trying the case, you find the language that establishes how the court views reasonable doubt. And quite often, the judge will read that reasonable doubt instruction in a criminal case. Well, if you know that the judge is going to read this and the jury's going to listen, maybe as you make your argument about what reasonable doubt is, you might take the language from that instruction and use it in the way you structure your case. Instructions are a shortcut for the substantive law in the jurisdiction to which they apply. And they're usually written by judges, lawyers, and academics who are on committees for pattern jury instructions. And they write them based upon where the law is at that particular time. So for example, when I was trying cases in the 90s, there was no instruction on cross-racial identification. Eyewitnesses were eyewitnesses, and the thought process was that the color of the skin or the ethnicity or the gender of the person that was involved didn't matter. It had no impact on your ability to see or to relate what another person is. Boy, if there was something that was fundamentally not true in the world, it was that. So what started happening in the 90s? Defense attorneys started bringing cases and putting expert witnesses on to talk about cross-racial identification. And then what happened? A case got decided that relied upon cross-racial identification. It was validated, and now in most jurisdictions, if you open up the instructions, the pattern instructions, there's a pattern instruction for cross-racial identification that calls into question the validity of it. And once you've established certain predicates in the presentation of your evidence, you can ask the judge for that instruction at trial. And the judge will give it. And then you can argue it to the jury. That's the way the substantive law works from an instruction perspective. That's how the common law changes over time. It's also how we continuously move our justice system towards a more perfect structure, towards something that's better for the people who are subject to it. You know, one of the joys of my job is I get to pontificate about what matters to me. It's 1:30 now. We into 2, right? Oh, good. I've got another half hour pontification to go. It used to fundamentally amaze me when I was a prosecutor. I would have young men and women that I was prosecuting that the evidence was overwhelming against. I mean, and I was the lawyer. I knew what was going to happen to them. Their defense attorney knew what was going to happen to them. They weren't in pretrial confinement. They weren't locked up. And they would show up in court and accept the judgment of the court. The entire system only works if people trust that it's going to function at some level in a fair fashion, however hesitantly or however imperfectly. That opportunity to be heard, you know, for a defendant who's done an awful thing, for the court to take the time to let that defendant's mother come in and testify on their behalf about their baby. You might be able to argue that that's not that relevant to whether or not he killed those 4 people, but it's relevant to him. It's his opportunity to be heard, to be seen by the court in his entirety, as he so chooses, as the defendant. If the system does not allow for that, the system does not work. The only thing that makes us submit to the legal system is our belief that at some level we're going to get some form of imperfect justice. If I don't believe that, as a rational thinking member of a society, you know, it's my duty to do something about it. That's how you get revolution. That's how you get civil war. That's how you get the overthrow of a government. And, you know, if you look at us right now as a nation, we are one of the oldest democracies on the planet at this point that has been in continuous structural format from its inception. You know, without massive changes. We're not like the French who throw their constitution out every 10 or 20 years and write a new one. We have driven this particular buggy into the 21st century. Why? Because there's some fundamental things in it that we all think are that doggone important. And one of them is the right of confrontation of witnesses. We'll talk about that through Hearsay this semester. Another one is the right to face your accused, to force that person to testify. The accused right to face their accuser, to force that person to take the stand and subject them to the crucible of cross-examination so that we can decide whether or not they're being truthful. Another one is the right to jury of our peers in both civil and criminal cases. And these things that I'm talking about are enshrined in both the Constitution substantively and the Bill of Rights. They're fundamental freedoms that were guaranteed to us. Every criminal defense lawyer, every prosecutor in the nation is making the system function as best they can. It's why when the prosecutor doesn't do it and steps outside the boundaries, it's a betrayal of everything. And the prosecutor has a duty that goes far beyond the criminal defense lawyers who's just taking care of one person. The prosecutor's taking care of everything for all of us, and it's their job to do that. It's their job. These evidentiary rules help us do that, but they also require us to do it the right way. So when I think of burden of proof in trial in the United States, there are only 3 burdens of proof that are required. And the first is preponderance of the evidence. And that's generally the standard in a civil proceeding unless the statute that created the cause of action has established a higher burden of proof. And preponderance of the evidence just means 50% plus the weight of a feather on the scales. The language that's most often used in the instructions is more likely than not. It's more likely than not that it happened. That's not much. It's why civil cases that are contested could always generally go either way, because there's evidence to go both ways. That's where good lawyers make an awful lot of money. An awful lot of money. Now, sometimes preponderance of the evidence shows up in a criminal trial, but only in the 3 things that I've listed on this slide: venue, statute of limitations, and voluntariness of a confession. And each of those comes from case law that have established in those types of cases that preponderance standard is applied. It's kind of interesting that that's the case. It might be worth just learning and committing to memory. It's just 3 of them. Clear and convincing evidence is more than preponderance, but less than beyond a reasonable doubt. When I was a law student, I needed a number to feel good about these standards, even though they will never, ever give you a number. So in my mind, I think of preponderance as being more than 50%. I think of clear and convincing as being about 3 out of 4, about 75, 80%. And I think of beyond a reasonable doubt as being somewhere around 95, 96%. I might have a doubt, but that doubt's a little far-fetched, right? When I look at the doubt, it's really not reasonable because there's other evidence that undercuts my concerns about the evidence. Clear and convincing evidence generally only applies in fraud cases, disbarment cases, and the validity of a deed or will. That's what the case law tells us. Rather than read all of that case law and assign it to you, I just put a slide up and say, remember this, because we've got more important things to learn. But you need to know it as a practicing lawyer. Yes, ma'am?
Can you put the last side up?
Oh! What did I do? Oh, I must have hit the button. I apologize.
Thank you.
I don't wonder why everybody was looking a little. I thought I must have stepped over a line somewhere I wasn't aware of. So, criminal is beyond a reasonable doubt. And criminal standard of beyond a reasonable doubt is not just to everything, it applies to every individual element of the offense that's charged. So if there are 5 elements to that charge, you got to prove all 5 to a beyond a reasonable doubt standard. Often in a criminal case, when it's contested, there's 1 element, maybe 2, that the government's going to have a hard time proving. And that's actually the fight. The rest of it just kind of happens through the normal presentation of evidence. Case analysis helps us identify the element or elements that where I need to focus my work, my effort, to meet the beyond a reasonable doubt standard. It's one of the reasons that we teach case analysis. And It also applies in the absence of mitigating factors when you've got an acceleration for the crime. Of more interest to me is how does the statute work for any defenses that are created. I'll give you an example. In the state of Florida, they had this thing, started about 2005, 2006, called the Stand Your Ground law. It was a law that was promulgated and pushed by the National Rifle Association. And the idea behind the Stand Your Ground law is that you don't have the common law duty to retreat when in a self-defense situation. If someone attacks you, stand your ground gives you the statutory right to respond to potential lethal force with lethal force of your own. So in other words, if someone approaches you with a knife and says, I'm about to stab you, you can pull your pistol out, shoot him in the face, and you're fine. Even if you could have stepped back, closed your door and locked it and been safe. No. You're allowed to understand your ground to engage in that fashion. But that wasn't the end of it. The Stand Your Ground law also shifted the burden of proof to the prosecution. So once the prima facie case of stand your ground had been made by the defendant, the prosecution then had to disprove the presumed defense to a beyond a reasonable doubt standard. Do you know who hated the Stand Your Ground law when it first came out? Prosecutors. Cops. Because you just said, hey man, it's the Wild West. And what happened? Shooting skyrocketed in the state of Florida. More people died. Now maybe that's the price of that constitutional freedom of the right to bear arms. I mean, we could have a talk about that over beer. But that's a classic example of where the standard of proof applied in a statute that was promulgated. Do we have a Stand Your Ground law in Ohio yet?
I think they enacted it this year.
I think they enacted it this year. I wonder who has the burden of proof on that Stand Your Ground law if the defense is raised. If I was an attorney in Ohio doing criminal cases, that is something that I would need to know. I fortunately am an Indiana attorney and it matters not to me at all, other than as an academic exercise. Although if I was going to kill someone, I might do a little research first. Do you know what else the NRA did down in Florida? They sold insurance policies to their members. You pay for the insurance, and then if you're involved in a shooting, you get your lawyer for free. And not only did they sell the insurance, but they then gave warning cards to all of their members. And it was a script that laid out the elements to establish a stand your ground defense. And when the cops showed up, they would flip the card up and they would read. My personal opinion might be that that's politics run amok in the criminal justice system. And the problem with politics in the criminal justice system is it's like a cancer. It eats away at fundamental rights that we all have. In a desire to push one thing to an extreme, we weaken the very freedoms that we had to begin with. I've seen it over and over again. Most of you are not old enough to remember Bush v. Boumediene, when President Bush put all the terrorists in prison in Guantanamo Bay. They put them in Guantanamo Bay because the thought process was it's not territory that's the United States, and it was an open question as to whether or not the Constitution applied. You know, things like habeas corpus, right to counsel. That was the Department of Justice's idea to avoid constitutional rights for those guys. And eventually it failed. Bush v. Boumediene said no. You know, what they wound up doing was establishing that habeas corpus extends all the way to where any American entity has control of a place. That law did not exist beforehand. Did not exist beforehand. So that's an example of the unintended consequences of playing with this stuff. I just kind of find it interesting. Relevancy. This is the actual game. 401 is logical relevancy. That's the part on the top of the chart up there. I have almost never seen 401 raised as a successful objection to prevent the admissibility of evidence. It's evidence having any tendency to prove or disprove some fact of consequence. That's a very broad pattern. Next week, we'll do the dead baby case, and we'll look at logical and legal relevancy through the rubric of the dead baby. That's a teaser. Legal relevancy is the balancing test between probative value and the substantial danger. And when I think of this balancing test, let's see, do we have a marker here today? Yeah, we do. When I think of the balancing test for 403, well, you never know, right? I'm the dean. I'm not going to carry markers around. They'll either be here or they're not, and if they're not here, I'll chew the dean out. Charlie, why didn't you have markers in that classroom? I'm sorry. I'll make it better. When I think of it, right? Over here is probative value. The more probative value it has, the more likely I'm going to be able to admit it. Over here, we have unfair prejudice, confusion of the issues, waste of time, cumulative nature of evidence. These are all identified in Rule 403 as reasons not to admit it. And the fulcrum around which it all rotates, the triangle, if you will, is the substantial danger of. So when I'm arguing about the admissibility of 403 evidence, it's a weight thing, where on the one side I have probative value, and on the other side I have unfair prejudice, waste of time, confusion of the issues, cumulative nature of the evidence. Here's the thing. Sometimes the more probative the evidence is, the more danger there is of prejudice. But the word that matters is unfair for prejudice, the unfair prejudice. So the argument is about whether the prejudicial impact of the evidence is fair or unfair. So for example, let's say we have a defendant who's charged with a burglary, and he's been convicted of 4 burglaries in the last 10 years. Serial burglarist, if that's a word. You know, think of Joe Pesci in Home Alone. Those guys, they did that a lot. So, if you're on trial for burglary, should the jury be allowed to know that you've been convicted of all these crimes in the past? Does that have probative value? Yeah, it has probative value. Bless you. Does it have a substantial danger of unfair prejudice? Well, that's a question that's fun to argue. You might want to look at how they did the previous crimes and how they've done this crime. You might want to look at, can I prove the underlying actions of Mr. Pesci and not the fact that a jury convicted him? Because a conviction by a jury is a government societal response to a trial. The underlying facts are the things that Mr. Pesci did or did not do on a previous occasion. The underlying facts might be admissible under a 403 or 404 theory of admissibility, while the conviction itself might be excluded because the prejudicial impact would be too high. And the probative value of the fact that they were convicted is not that great, absent the underlying facts. What I just described for you there is the intersection between 609 and 404B, which is one of those really thorny issues in evidentiary law. If you understand that at the end of this semester, you are well on your way to being an evidence guru. Because that's about as difficult as it gets for first-year law students when it comes to evidentiary law. Fortunately, you have me. I love that stuff. So I'm going to beat you over the head with it till it sinks in. Metaphorically speaking, of course. Anybody know who that is? It's Casey Anthony. Yeah, Casey Anthony. I did news commentary for the Casey Anthony trial. It's kind of fun. Character matters to us as human beings. The type of person you are is a fundamental question that we ask. When we form friendships, when we form long-term relationships, we weigh character when we make the decision of whether or not to associate ourselves with others. Heck, I did it with everyone in this room when I decided whether or not to allow you to be admitted to the College of Law. I weighed your character. Tried to do it transparently, but I did it appropriately. Some questions I didn't ask you, but others I needed to know. We do that as human beings. Character matters to us, sometimes more than facts do. Because if the character is the right way, we might overlook a little misconduct because, after all, they're a good guy. We could have a long discussion from a jurisprudential perspective or whether that's a good idea. But we know this about human beings. We know that people like to shortcut emotional reason and go to character. So, these rules, 404A, 404B, 405, 608, and 609, all deal with the character of a witness or a defendant. The 404s, A and B, apply solely to the victim or the accused in a criminal case, or the respondent or the plaintiff in a civil case. 405 is a rule of procedure that tells us how to admit evidence that's deemed admissible under 404. 608 and 609 apply to all witnesses who testify. But 404A and 404B don't. It's a smaller subset of those witnesses. It's a smaller subset. So understanding these rules, where they overlap and where they are separate, is a key component of getting character evidence right. It's literally a Venn diagram. And we'll draw some Venn diagrams as we play with the rules on this semester. I kind of find it interesting. You may or may not. This slide is in your classroom folder. I'm not going to talk about it now because there's a ton of substantive law there. We'll spend about 2 weeks in class going over character evidence. This is the 608 rules, or the 600 series, which deal with witnesses and witness testimony. Article 6 of the Federal Rules of Evidence deals with witnesses, what they can't say, and how they can say it. And we will go over that a lot this semester. You just need to be aware of it right now. And then impeachment, well, that's how we confront someone who's lied on the witness stand or whose credibility we wish to question. And all of that list right there, there's a federal rule of evidence or federal rules of evidence that allow us to inquire about those things. And what's amazing is that I can ask questions about this stuff for impeachment purposes, if that's my purpose, but I could never ask questions about a lot of it for substantive questions if I'm trying to prove the evidence of the underlying bias. That's kind of fascinating. I love impeachment. I love to teach it in large part because I get to show a whole bunch of video clips. It's like movie week with Professor Rose. Because when you see it in action, you understand that it has some particular meaning. And then hearsay, and I'll end with this slide today, guys. Hearsay is an out-of-court statement offered for the truth of the matter asserted. It's an OCS Arrow TMA, an out-of-court statement offered for the truth of the matter asserted. And it doesn't matter if the person who made the out-of-court statement is the person who's on the witness stand. It's still an out-of-court statement that you now want the jury to hear for the first time. A lot of evidence books spend an inordinate amount of time talking about hearsay. They spend an inordinate amount of time engaging in philosophical discussions about what truly is a statement and what does it mean to offer it for the truth as opposed to something else. Those are fun conversations to have over a beer, but it confuses students who are first coming to the doctrine. You will learn hearsay this semester as though you were a child playing with your toys. What do I mean? Most of us have children or were one at some point in time. Do you remember the box that you would get that had holes in it, and each hole had a particular shape? And you would pick up the block, and you had to find the hole that was the shape of the block to put the block in the box? That is hearsay doctrine. Every hole in the box is a rule that allows for the admissibility of a piece of evidence. Your job as the lawyer is to pick up the right block, i.e., argument supported by the facts, and drop it through the hole to admit the out-of-court statement for the truth of the matter asserted. This means that to understand hearsay, you must read early and often all of the 803 exceptions, the 804 exceptions, and the 801 exclusions. Here's the rub. 801 is excluded by operation of law from hearsay doctrine. So on a multiple choice test, if the answer is an 801 question, it's admissible, not hearsay. Sometimes evidence is admissible non-hearsay because we're not offering for the truth of the matter asserted. Sometimes evidence would not be admissible under an exclusion, but would be admissible under an exception. So that's where the confusion lies. You won't be confused by the time we're done because I'll identify the most common exceptions that you use in day-to-day practice of the law, and we'll go over them and you'll understand them. You know how to see them and to make the arguments about them. The only thing in hearsay law that is complex is the right of confrontation concerning custodial evidence. And that's doctrine that was created by Justice Antonin Scalia. It sprung forth from his head like Athena from the brow of Zeus. And it's actually great doctrine. I'll tell you some stories of how that came to be when we get to it. But that's a series of cases that we will read in this class because we've got to understand what testimonial immunity is. Because if there's something that's going to change in hearsay law, in my estimation, over the next 10 years or so, it's the potential application of Crawford to other 803 exceptions. Now, before this court was constituted as it currently is, I didn't know how likely that was to happen, but if I was a betting man now, I think that it's quite likely that at some point we're going to see that. I also think that we may see a revisiting of the Katz doctrine when it comes to privacy and the right of search and seizure, but we'll see. So, guys, that is the walk through evidentiary law that we're going to cover this semester.